Okay, welcome back to Senate Institutions on February 26th. And we are still working on S69, Act relating to age appropriate design code. And we have Attorney Rick Sagel with us now, Ledge Council Attorney. And we have a proposal of amendment, which is not a strike off, which I appreciate. And the committee members and the folks here have paper copies. Oh, is it online?
It will be momentarily.
Okay, it will be online soon. And the highlighted and underlined language is the new language. So, Mr. Sagel, if you will walk us through this, please.
Yeah, Rick Sagel, Office of Legislative Counsel. This is draft 1.2. And as the chair said, I'll kind of explain why I structured this way, but the yellow highlighted, you gave a color copy version. I hope you all have a color copy version. That is the new language. And we'll start with section 1. Section 1 is just dealing with the exclusions of the bill. In other words, what entities or what kind of things don't apply, are not covered in this bill. So 1, 2, 3, 4, and 5 are carried over from the introduced version. They'll recognize that language. 6 and 7 are new. And I'm going to start with 6. A person who controlled or processed the personal data of not more than 25,000 consumers, which means Vermont residents, in the previous calendar year, excluding personal data controlled or processed solely for the purpose of completing a payment transaction, or 50,000 consumers in the previous calendar year, excluding personal data controlled or processed solely for the purpose of completing a payment transaction, and had an annual gross revenue of not more than 1 million in the previous calendar year. The previous draft had that 100,000 consumers, and the realization that the Vermont has 650,000 people, that there's two fairly wide of a net there, and actually, I'm sorry, too small of a net. That a lot of Vermonters that you're requiring the company to include. So we actually mapped the number to how Connecticut kind of structured their consumer calculation. Theirs is 100,000. Connecticut has a lot more people than Vermont does. So we kind of made that more of a ratio specific to Connecticut. And then 7, a financial, this is language from Christelia, but we all use the same language in the Data Privacy Act this year and last year. This is pretty standard exemption for a financial institution or data subject to Title V of the Gramm-Leach-Bliley Act, federal law, and regulations adopted to implement that act. You may have questions about that. Okay, I'm going to defer to Chris if he can explain that. So that's your exclusions. These entities are not covered by this law.
Okay, and just to reiterate, this language is in response to concerns of committee members that too many businesses were going to be impacted by this.
From the original draft, yeah.
Yes.
From the introduced version, correct.
Yes.
Okay. The second instance of amendment on line 6, page 3. Senator Douglas had a concern about the video games causing emotional distress and compulsive use. So I found a way to kind of make this tidy, and by striking out subsection C and replacing it with just so let me go back a second. The way the amendments work is you strike out the entire subsection and you put it back in, and here I've highlighted what's changed in the subsection. So the highlighted portion is what's different than what is in the current version of the bill, if that makes sense. So the current bill says the content of the media viewed by a covered minor shall not establish emotional distress, etc. The amendment would add the phrase for the video games played by a covered minor. Now, I will kind of put this out there that that's a huge loophole. And it's because how would you define a video game? A video game could be Candy Crush, it could be PlayStation, it could be Xbox, it could be an app on your phone. So while I think it maybe gets the idea that you want to exempt these types of games from that portion of the law, I would maybe want the committee to consider, is there a better way to word that than what I've suggested?
Well, Candy Crush isn't social media. And social media is the intent of the bill. So, I mean, and I really don't think that you could ever call Facebook a video game, even if it has video games attached to it, like Farmville, because Facebook is not a video game, it's a social media.
So I just, right, and I want to make sure you understand that the intent is not social media, the intent is to protect minors from harm caused by apps that may be social media apps, it might be games, it might be other things. So I don't want you to be misunderstood and think that you're, because this would cover video games within social media, but also probably other games that are externally from social media that you just download or you plan on a website. If they meet the other consumer threshold, they'd be covered by this law. Just want to make sure.
So let me ask you a question. What about video games that are not connected to the internet? Because I thought that was what your concern was.
Well, it's not just games that are connected to the internet, but my concern is games that are intended as just entertainment. They're not intended to addict a person to keep them on there. And those can be online, they can be also offline. So no, that wouldn't specifically cover it.
Yeah, what I was hearing from folks was there are games that are intended to keep folks.
No, certainly maybe some, but I would argue the majority of the industry is not that case.
Right.
The vast majority of the industry.
So how would we distinguish between?
Well, besides just naming them specifically, which
we can't do.
Yeah. So you're in essence punishing an entire industry for a small subset.
Is it?
Of the?
Is it a small subset?
I would argue it's a pretty small subset. There certainly are. I mean, okay, there's probably millions and millions of games in the market. So yeah, there might be thousands of games, but in the percentage of it, what I'm saying, like.
This is a question.
It's also hard to differentiate between intent and non-intent, because a game that uses, like, let's say buying in-game items or something, that can be intended to just be part of the game. That's fun because people want to buy an in-game item because they want to customize their character or whatever. That it may not be intended to be addictive, but for some individuals it could be addictive. But it's very hard to draw the line of intent versus part of the game.
Yeah, and I guess what I would say is there are a lot of fine things about Facebook, and we aren't trying to shut down Facebook or anything like that. We're just trying to prevent deliberate harm of children.
Mm-hmm. Well, what's deliberate?
Well, we know that. I mean, it's the algorithms, and it's also the selling of the data. I mean, we heard some pretty brutal testimony on that.
Mm-hmm.
So if that is happening in video games, I think we need to.
I would definitely argue that I don't think there are very many at all video games that use an algorithm to keep on the game. The game itself could just be very fun to play, and people might want to play it for a long period of time. But I don't know. I mean, I'd love to hear from an industry perspective of whether or not there are video games that use adaptive algorithms to keep people on there longer, like social media companies are able to do.
Right.
So I think something
I'm sorry, she testified yesterday about that.
I didn't hear that.
Yeah, it was something about basically, I'll call it studying the patterns of how the game is played, and at a particular moment in the game, I believe that she used I could be wrong, the moment of dying in the game, then something, gets popped up. I pictured it sort of like you're in the arcade, and you die, put another quarter in to play, but I'm older than a lot of people, so I did actually go to an arcade. But
They're coming back, actually. They're popular now.
they are, yeah. The Dream Machine the Kmart Plaza was. But anyway, so sorry, I think for
No, I was just gonna say, might be, I'm looking over the definition of compulsive use again. I think we just think of that, the term is just like, compulsive could be just, oh, I wanna keep playing the game, it's really a fun game, right? But if I look at it, so it's on page 3 of the introduced bill, means the repetitive use of a covered business's service that materially disrupts one or more major life activities of minor, including sleeping, eating, learning, reading, concentrating, communicating, or working. And yes, a good lawyer could tear into that and say,
Yep.
oh yeah, look, this game has caused my clients insufferable harm because he or she cannot eat or learn, right? So something to keep in mind is this term is defined, and you can also change that definition. You could suggest a different term for the video game content. I don't know. I'm just throwing things out.
No,
Maybe.
thanks.
and just to go on to that, the compulsive behavior of suppress they're defined. But what the minimum duty of care is, you don't use the data and design the online service to do those things. So reasonably foreseeable, sure, but it's designed to do that.
Or using data, using somebody's data to,
Let's go to page
because I don't,
14,
when you buy a
line
game,
14.
they don't use any specific data, but I can't imagine how they can use specific data. of the-
Exactly. It's limited. So,
So then
yes,
what's the problem with the amendment?
there is no problem with the amendment. I'd
Oh,
say
okay, cool.
including the video game played by a covered minor instead of or the video games, because the video games played by a covered minor is just the content of it. That's the concern. The thing the order including. But I think that the video games played by a minor is just covered by the content. But that's just.
It's covered by the content.
Yeah. I think Sam or Senator Douglas's concern is a content concern. And we're not talking about, so. Or we're excluding content from.
Right, we're not regulating content. Which means,
So, and I brought, so I'm kind of swapping gears here.
yeah, well, I just want to be clear on this.
I think if you put the or in, it makes it so that video games played by a covered minor is absolutely unclear and we don't know what that means. But actually it's just the content that we're talking about. So if it's instead of or, it's including the video games played by a minor, it just gives an example of what the content is. I don't think it's necessary, but it alleviates the concern of, any video game company that provide an online video game, because that's also another limitation. It keeps them from having that anxiety that, oh, I provide a video game, my games are just, dopamine fixes anyway, so therefore it'll lead to compulsive behavior. But that's just the content is what we're talking about, not the mechanism for which it's served onto the.
Hmm. You kind of see that both ways. Did you have another way of, are you talking about like commas in this? Is it including?
I would do covered minor, comma, including the video games played by a covered minor.
So a video game would be considered a content. That's what you're saying. An explanation
Yeah,
of
the
content.
concern is the content of the video.
I have it on the screen. Madam Chair, if you want. I think I.
Oh, I see,
Yeah.
including video
I have
games
another comma.
and another comma, yeah.
I don't know what your punctuation manual.
All right, so our official attorney, what do you?
Wow, commas.
I knew you did. It is a very interesting point. I hadn't thought of it that way. That, does content include? And I'm trying to get away from the term video game and just thinking like in general, playing a game. When I think video game, I think holding control. I know that's not always what a video game is. It's, because
You're engaging in the activity of video.
of a game, yeah, and it could be an arcade game, it could be an app, it could be anything. It could be just a weird Pong on your phone. So I'm thinking in some ways it makes sense that this is just an example of what we're talking about, but also it would not include someone who says, I have had some kind of compulsive use caused by overplaying this game. This game has caused me distress because I can't put the controller down. So I don't know if that type of harm would be exempted by doing this.
Yeah, and also I don't know if you can differentiate between content and playing because I don't know. I think the original language is better. No offense.
Well, it's better as far as exempting a lot of acts. Like if you have the way I put it, any game is not going to be subject to this law for those two, for the compulsive use and the emotional distress. It's still for the data. The data stuff is still protected, but it's a big loophole. I'll put it that way. And it is the intent was of, because I think you wanted to exempt video games, and this was my way of like, I think this makes it happen.
What would you think about video games that aren't connected to the internet, that are standalone games?
I mean, yeah, but there's still the problem of there are a lot of games that are, I mean, you can play a lot of the games that we're talking about, that Rick's talking about, that are handheld, that are apps on your phone. Let's say Candy Crush is an example, but not necessarily Candy Crush. You can play a lot of those games offline, and they're not actually games. Yeah.
I mean, I see a difference with offline,
Those games still be addictive though. I mean, I think that's
right? But I mean,
But
And how do you-
is the addiction through an algorithm?
no, but I'm not sure where algorithms in this bill. I also want to make that clear. I'm sure it may be somewhere, but like the intent here. Yeah,
It is with design that is.
yeah, it's like,
it's
I want to
fine.
make sure that we just to make sure, this bill covers quite a bit. And we're talking about, a compulsive use of an app, a game, a social media platform, anything that's digital, right? I think it's as long as they have the consumer threshold, right? So that can be an offline game, it can be a social media app, it can be a messaging app. But if you want to extend video games, it's going to be hard. And I think that in some ways defeats the purpose of the bill. I think the intent from this language that I didn't draft originally is to ensure these games do not cause harm to children and, compulsive use harms to children. So I think if you do this, you are cutting a pretty big chunk out of the bill. But you have the full right to think that this is making out the best use of language.
well, in the other, there have been other versions, not just here, but in other places. Do you have any idea if the video games folks have had a problem with the other ones?
It's something I have to look into. I mean, they're challenged by usually big, like NetChoice is a big
Yeah.
tech lobbyist, and they usually are the ones that follow the suit because they have lawyers that follow the suit. And I'm guessing that there are usually video game conglomerates in that lawsuit, but
Mm-hmm.
Which the intent was actually written in.
I'm not a fan of the tech language, actually, personally.
No,
No, the law can speak for itself. And if you don't,
yeah, I like it too, since then you know what the bill's trying to do.
Yeah.
Yeah.
Was that a deal breaker for you?
Probably. Couple other things.
What are the couple of?
Yeah, it's fine. But I do have another thing I wanted to bring up. And I mentioned this earlier and you seemed interested. That was adding an exemption for businesses that primarily engage, have an exception for businesses that primarily engage in online services. So it would absolutely rule out any company that sells backpacks, because that is not the primary amount of their revenues on online services. It's from selling of a physical product. And I think I scratched in some, right here. So under covered business, definition 11.
What page?
Oh, shoot, sorry. Just the affiliate thereof that conducts business in this state that generates the majority of their revenue, from online products and on whose online products, services, and features particularly. Yeah, so just that generates the majority of the revenue from online services. So covered business would only mean a business that gets a primary amount of the revenue from online services. So it definitely would carve out an exclusion for companies that sell backpacks or any other physical products like Vermont Country Store or Maple, for instance.
Right, which I believe is the intent.
I don't know, Rick, there's not.
Well, what's stopping a company that mostly makes backpacks from, making an app that is addictive would be the argument I could see.
Oh,
But again, at some point, if that app's really good, it might take up more of the revenue and would a majority of such language you suggested.
So I guess I'll kind of go into my spiel about how I think that this bill is very limited and all of the concerns about it being covering so many businesses already in there. So covered businesses broadly defined. But there are certain things that basically all businesses can do. And that is all directed towards minors. And so they can't design their product to cause emotional distress for someone they know to be a minor.
Who determines that? Who determines what emotional distress is?
No. Well, the emotional distress, you generally don't know it.
This is
But
what
this is have
I'll let
to
you
be
say what you want to say.
intentional to design it to cause that emotional distress. So Vermont Country Store.
But who defines that? Who defines that?
Who defines?
Who defines that? Who defines what emotional distress is? They have lizards on their service.
I'm gonna just, I was trying to get into that this is an incredibly pro-business bill. I know you don't think that, but this is, it.
This is a attorney's dream to sue businesses, and it's all it is for a bill.
And the only business that would really be thinking about this would be people that want to do it to the kids. Because it's only the kids. Only the kids.
No, it is not. But
Wait,
we disagree.
If you can point to me where it isn't only the
It's
kids.
so wide open as far as an attorney. This is a class action lawsuit ready to just sue and sue and sue.
Section.
All it is,
Section
every bit of it.
2449A definitions.
Yeah.
2449G is exclusions. 2449C only applies to covered minors. 2449D only, all of those things, covered minors. And then we get to 2449E transparency. This maybe applies to more businesses to be transparent about what they're doing.
I don't know why it's so hard to write a bill, just like what we would write, just like we would tell our kids. Don't do this. And then go to that and say, okay, when we're talking to you, don't do this.
That's what
This
this,
bill, no, it does
that's what
not.
this does.
well,
No.
lots of attorneys have told us that that's what.
Yeah, okay. Well, lots of attorneys have told me just the opposite.
Well, I wish they would come and talk
So,
to all
There
of
are
us.
they don't-
laws federally that do name specific companies.
Right.
Sure.
That's why they're not even gonna waste their breath on it, because they know as soon as this thing gets passed, it's gonna get struck down, and that's the way it is. So that's just the way it is. What's gonna happen?
I gave my pitch. I tried.
Well,
I mean,
we all
this-
try.
This is remarkable. I think it's remarkably
Well, I mean,
good for businesses.
talking about covered minor too, or sorry.
Yeah, go ahead. I can help people go on your route. Deals with it.
So, well, talking about covered minor, or labels as a minor pursuant to age assurance methods and rules adopted by the attorney general. So we've heard a lot of testimony that age assurance methods are not great. They do their best, but they're not great. And then if you look at the back of the thing, when it talks about rulemaking, it does say, oh, geez, let's keep going. Oh, here we go. In adopting these rules, the attorney general shall prioritize user privacy and accessibility over the accuracy of age assurance methods.
Right.
So if they're trying to prioritize user privacy and accessibility over the accuracy of age assurance methods, I do see that as opening a big door to those age assurance methods not being very accurate. So if a business is labeling somebody, the consumer, as a minor, or sorry, if they're not labeling somebody as a minor, those age assurance methods are not very good, then they can have a lot of people who are minors are labeled as not minors, as adults.
So what that is covered minor is someone in the business knows to be a minor.
So labels as minor.
So knows to be a minor. So whoever sues would have to basically say, this is how we know with absolute certainty that business knows this person is a minor. Or the business can look to the Attorney General's rules and on their own decide to use those rules and add that label to a customer. So that would be their choice to use a method that comes through rulemaking. That might not be completely accurate, but this business is interested in protecting more kids than the law requires.
So Rick, would a business not have to imply the rulemaking that the Attorney General is going off what Senator Plum was just saying? Or would a business have to imply or employ rather those rulemaking, those agencies?
So yeah, the statute calls the AG to have that authority, and the rulemaking would be just as good as a statute. So the rule, if accepted, which there is, by the way, lives in a process of rulemaking. It's not great, but they come here and they propose a rule, and you're allowed to object to it. And there can be some commentary. But to answer your question bluntly, yes, they would need to.
And so it's
Okay,
so it's
okay,
not
hold
just
on. No, but they can, but some rules have options. So yes, the businesses would need to comply with the rule, but we don't know what the rules are gonna look like, and a rule could have options.
Right.
Okay, so the business could have options.
It certainly could, but we've heard testimony that those methods of age assurance are not great. And I think I think we all agree on that. And and the language that the Attorney General has to make sure that what was it? The language over age assurance models is more important, privacy or whatever is more important. So if the age assurance methods are loosey-goosey, then there are going to be, I love the use of loosey-goosey legislator, that's great. I think there might be covered minors slipping through the cracks. And that's another one.
So if you're worried about minors not being covered by this legislation?
And no, minors, well, yes, minors slipping through the cracks, and then businesses having consumers who are not labeled as minors.
Okay, so I think we all saw a lot of harm from the existing situation, right? I mean, business as it's happening now is causing a lot of harm. I believe that we demonstrated harm
It's to what? Harm to what?
to the children.
Okay,
I
to
mean,
what? And this is the only way that it happens?
it's the way to start, sure, sure. To me, the harm is very clear. And I mean, we can get more testimony, but especially with what we heard yesterday.
Time you are, Madam Chair.
Okay, I just think it's important to note that the harm has been, at least for me, demonstrated very completely. And, that it's existing Vermont children are getting harmed. Their families are harmed when they are harmed. And they're being harmed. And companies know, one of the ones that really, shocked me, which I shouldn't be shocked at this point, is I think it was Instagram where young women, when they were young women, would get certain messages and their information would be probably sold, right? Is what we heard, or given to men. And then when they were over 18, they didn't get those messages anymore. So that's very deliberate and harmful. So that's what I heard. Did y'all hear that yesterday? So it's deliberate. They know the ages. I think when folks talked about the age verification, that conversation had more to do with kids saying that they're older than they are.
Right.
And
Would you
that
say they know the ages, who knows the ages? Company?
yeah.
So if
Yeah.
the company is the only one that knows the ages, then how are individuals, strangers, contacting them specifically because they know that they're minors? Unless these
No.
are,
The companies are providing that information to people who they know want to know. Young,
so,
mostly young women, probably young men, I would say too. Okay. Um,
How would you like to proceed?
well, I would like to vote this out of this committee. I prefer a good majority vote. But I don't know if that's possible. Senator Ingles, I
I
guess.
think you know where I stand, Madam Chair, and I'm gonna be very respectful of what you're trying to do,
Okay,
so.
okay.
you're looking at me now?
Yes, I am.
My answer is that I don't like being the swing vote. That's my answer.
You don't what?
I don't like being the swing vote.
Yeah, that's not fun.
Going back to my amendment, that generates a majority of their revenues. Rick, do you, could be include that in the packet?
Are you asking, could that be added to the amendment?
Yeah,
Sure. So you would want it to say,
it conducts business in the state, comma, that generates a majority of the revenue or a majority of its revenue from online products and whose online products would
generates a majority of its annual revenue
yeah, I'm fine with
from,
that. I mean, as long as it's legally good. I mean, I agree with the intent.
annual from the sale of online products, is that,
Sorry, what?
from the sale of online,
Majority of its revenue from online services, I think was.
online services?
Yeah.
Okay, yeah, if the committee would like that, basically you would, I may tweak a couple of the words, but that's, I think you understand the gist of it, so. I don't think that, trying to think any things to be aware of if you make that change. I already gave one example of a small company that mostly sells physical products, but produces an ad that's harmful. But if that ad gains popularity, they make the majority of the revenue eventually from that. So that's one thing I think of off the top of my head.
Okay. You guys go with that? Change it?
I think that none of the concerns are really affected by the bill as it is. Only the banking change, I think.
Is what?
Only the
It's
banking
needed.
change is
Subdivision
is appropriate.
Mm-hmm. What about the, 25,000
Yeah.
customers?
I think that it's not needed. That
Not needed?
So few businesses would be wrapped up into this, but. You know, I don't think it's needed.
But I would keep it at this though.
Yeah, I mean, I wouldn't go in favor of that. But I think it doesn't do much.
Mm-hmm. Okay, I think, yeah. All right, and we have the comments on the video games, right?
No, Senator Douglas wanted to keep it.
You want to get
as
the
it is.
comments out?
I'd rather keep it the way it is. I don't,
Well, and this is going to other.
Yeah,
This is. All right, so how about you get us language that makes the change on page 4 to covered business? And add that to these.
Mhm.
And, then we'll, okay, so you're good?
yeah, I think that's the last one.
Okay,
So comma or no comma on the screen?
no comment.
it would be back to the way it had before, just or not. Okay.
Okay, and so let us take a recess while you make those changes.